Tonight, we turn to New York City, where a rookie New York police officer is pleading not guilty to the charges in the shooting death of Akai Gurley. This after the officer indicted in the case, why Gurley's family members lashing out at New York's top cop Bill Bratton. Our legal panel joins us tonight to weigh in on the charges in the case. And, well, the check cleared, but does that mean the legal wrangling surrounding an oil tycoon's divorce is over? His wife agreed to a settlement that was a shade under $1 billion, but she says she's being underpaid in this. We will ask one of the leading divorce attorneys in the country here has handled some of the most high-profile cases, whether this case is really closed and whether the wife actually got a raw deal. Plus, we will head to Alabama, where a chief justice is telling state judges to order a federal court, disregard a federal court order allowing same-sex marriages. What could come of this kind of insubordination? And is the Supreme Court here poised to make same-sex marriage the law of the land? Good evening, everyone, and welcome to RFL. I'm Richard French. Thank you so much for joining us. And tonight, like we do on Wednesdays, we break into a lot of legal issues, and tonight we're going to spend the whole hour on them. And we'll start in New York City, where a rookie cop, Peter Liang, pleading not guilty to the charges he's facing in the shooting death of Akai Gurley. A Brooklyn grand jury indicted Liang in Gurley's death. That in itself is a story. We'll get to that in a second. Now, Liang is facing 6 charges, which include manslaughter, criminally negligent homicide, second-degree assault, second-degree reckless endangerment, and 2 counts of official misconduct. As we've reported, police say that Gurley was accidentally shot and killed by Officer Liang in the stairwell of a Brooklyn housing complex last November. Police say Liang was patrolling the Pink Houses rough housing project here when he opened fire on Gurley. Gurley was just walking down a stairwell because there was a broken elevator here, was shot in the chest and later died. Liang was on the job less than 18 months, and today Gurley's aunt spoke out, attacking Police Commissioner Bill Bratton, accusing him of siding with Officer Liang.
To Commissioner Bill Bratton, you said that you are sad that Peter Liang was indicted. Are you serious? Are you really serious, Mr. Bratton? Why do you think that he should not have been indicted? A black life was lost. Murderer, murderer, murderer. That's what it is. Modern day lynching murderer. Yes. Being protected by the law.
Well, some are questioning whether the indictment in this case, you're hearing phrases like makeup, and that obviously coming after the fact that there was no indictment in the Eric Garner case, obviously the case we've discussed at length here that happened in Staten Island. And Chris Smith, friend to the program, who's a writer for New York Magazine, he wrote that despite the indictment in the Gurley case, quote, there will nevertheless be plenty of inflammatory political and racial interpretations of why Liang was indicted and Officer Daniel Pantaleo, the officer in that Staten Island case, was not. That Thompson, who is African-American and the district attorney in Brooklyn, was intent on proving himself in his first truly high-profile police case, and that the Brooklyn grand jury likely included more black members. All right, I want to bring in our legal panel on this. Jimmy Koutsouras, criminal defense attorney in Manhattan, lecturing at New York Law School and also visiting professor at the University of Birmingham in England. Doug Von Oist, founding partner of Carson Von Oist, focusing on corporate misconduct, himself a former assistant district attorney, and he has recently been selected by the Legal 500 as one of the most influential trial attorneys in the country. Mayo Bartlett, attorney and also former chief of the Bias Crimes Unit at the Westchester County DA's office, and also Nobel attorney handling high-profile civil rights cases. Mark Furnish, professor of Brooklyn law here, defense attorney in his own right, and he has argued before the U.S. Supreme Court. And Mayo, I'll start with you. We saw the pain reaction from the aunt here of Mr. Gurley. Nonetheless, after Ferguson, after what we saw in Staten Island, there was an indictment out of a lot of doubt if a attorney general should handle, or a DA, excuse me, should handle cases when obviously they involved and interact with police on a regular basis. Thompson said, I can handle this, and then by the indictment it seems that he could at least get what he was pursuing, and they didn't have to go to an independent prosecutor. Starting from that end, what, if anything, did the indictment prove to you?
Well, the indictment showed that if a prosecutor is interested in getting an indictment, you can get one in a case like this. And it begs the question as to whether, if this same case was presented in Staten Island, there would have been an indictment. I would not consider this a makeup because you have two entirely different offices, two entirely different political dynamics. You have D.A. Thompson, you have the district attorney who is in Staten Island. Totally unrelated. They don't work for each other independently. They are prosecuting crimes. Now, what it tells me is that if you put cases in the grand jury as you would against any other citizen, you can get an indictment. And if you look at the average citizen, if you were to simply dump all of the evidence into the grand jury and then to present it the way most of these cases that involve police shootings have been presented, you'd have far fewer indictments. The other issue is that he treated the officer as a suspect from the beginning. So there was unequivocal. And the other thing is, if you look at the spectrum of charges that were given for them to consider, they ranged all the way from misdemeanors, actually, from official misconduct, all the way up to manslaughter. But what you didn't see is a murder charge there.
And
you
the
didn't see
argument that they've tried to overcharge in other cases where they couldn't secure an indictment. If we could, guys, if you could bring up the list of charges that the officer is facing here. And Jimmy, I'll bring you back to your ADA days. Talk about the threshold that has to be proven here against Officer Liang. And just to give a little context to this, and we heard the impassioned words from the victim's family, but few people, I've heard at least, think that Officer Liang and his fellow rookie partner went to this housing project where they went in a dimly lit stairwell. Now, they shouldn't have took their guns out, and that's, I guess, part of the official misconduct. That's against police procedures here. You don't walk out with your guns drawn. They weren't responding to an incident. They were just doing a vertical patrol. Nonetheless, door opens, gun goes off, and he kills him. Obviously, I don't believe he intended to go out that day to murder Akai Gurley, okay? Nonetheless, talk about the threshold that has to be proven there. Do he have to have intent to get will he almost have to show intent to get a conviction?
No, you absolutely don't, because you're charged with reckless crimes and you're charged with negligence. And so in the grand jury, you need to simply show that it's more probable than not that the elements of the crime have been satisfied. But more to the point, it shows that when you want an indictment on particular charges, you're going to get them. I'm sorry,
unless you're in Staten Island.
I do think it's a makeup, because Ken Thompson was saying from the very beginning he's going after what clearly was an officer who did not intend to commit a crime, and for an incident that clearly was an accident, and this is an indictment overcharged. There cannot be, in my view, recklessness out of this. Criminal negligence, possibly, but for recklessness, you need to be aware of the risk and you need to disregard it. And here, he's opening the door, unfortunately and wrongfully, with a gun in his hand. He is not aware that anybody's in there. It was a confluence of events that turned into a tragedy. But I do not see recklessness here, and I do see it overcharged.
I see recklessness on the part of the NYPD for sending a rookie 18-month officer into a dark building doing this controversial vertical policing tactic. This guy is now being made a scapegoat for the entire police department. And if I were defending this man after that outburst I just heard on the stairs, you might have thought there was no indictment returned. This man will not get a fair trial here. I applaud the decision to keep it with Thompson. I'd be moving for a venue change somewhere upstate tomorrow, because there is no chance with outrageous speeches like that that this guy will get a fair trial.
Mayo, if you were defending Officer Liang, would you be looking for a deal right now, or would you say a mistake, albeit a tragic one, shouldn't result in a conviction on one of the more serious charges he's looking at, manslaughter, for example?
First of all, I would say that it's definitely not a makeup, because every single day people are charged with criminally negligent homicide. People who get in a car and speed, they're not intending to kill anyone. They get charged. Nobody screams it's an overcharge. That's what the statute's for. That's why you have that charge. It's an E felony, maximum jail time, 4 years in prison. I would be basically exploring what the facts are here. You got to be mindful that this officer, instead of rendering aid to the man who he mistakenly shot, spent all this time on the phone with his PBA rep.
We're still waiting for confirmation, but what Mayo's referencing, for the audience who doesn't know, is, was the first phone call after the shot went off that hit Mr. Gurley, was it to 911 to try and emergency bring in EMTs there, or was it to his police union rep, as has been the allegation? There's yet to be confirmation on that as of now. Doug, same question to you. if you were prosecuting the case, would you have gone for the same charges? And now you're presenting it to a jury. What are you trying to convince him that this man was guilty of?
Well, I definitely would not present these charges, because when you overcharge like this and you put in something like manslaughter, you're really taking the whole case and you're really minimizing it. This is a civil lawsuit that you're looking at right here. You're looking at a police department that trained this individual. He was trained improperly in some way, or he was chosen as a police officer, and he should never have been.
Okay, let me play devil's advocate, though. I'm going to hear, if I'm on that jury, I'm going to hear from relatives of this guy who says, time out. Are you telling me that because I live in a building that's in the wrong zip code, that a guy's walking up the stairwell with a gun pointed when you, Mr. Attorney or whatever, you don't have that, Officer Liang or whatever else? My son, my cousin, my uncle, my brother, whatever, isn't coming home tonight because an officer didn't follow protocol and he shot him in the chest and didn't make the right phone call. Why is that a civil case and not a criminal one?
Well, this is what I was trying to say. When you charge this man with manslaughter, and he could potentially get acquitted of these charges, it makes it look like he didn't do something wrong. He did a million things wrong in this case, and so did the police department itself in the training. He may have personally done it, but when this is put into a criminal context with the wrong charges, ultimately it can look like he did nothing wrong.
But he gave a bunch of charges, right? So don't you explain to the layman here at the table, if he put in a half a dozen different charges, why doesn't the jury, why don't we have time for them to figure out what he wants to go for?
Well, because, again, because when a prosecutor puts a case into the grand jury and wants an indictment, he's getting it. And he's most of the time getting it on the charges that he presented. It's as simple as that.
He could still go for some of the lesser included ones instead of manslaughter,
absolutely,
right?
and I don't know if it's only a civil case. I'm not saying that crim neg is not a possibility here. Clearly, official misconduct is a possibility here. I don't see recklessness. Recklessness has to rise to the level where he opens the door, he sees the kid, and he fires the gun, disregarding the risk that he's going to hit him.
Changed the policy such that rookie officers like this one will not be sent into this death trap.
But that's after the fact.
Well, to me, that's a veritable concession that the police department is at fault here. If I'm defending this guy,
they've already said that they're now changing that no longer will rookies be paired up in this kind of.
So how is he to blame for it?
The other thing is you do want the police department to take corrective measures. However, if you're not supposed to have your gun unholstered unnecessarily, why do you have it unholstered unnecessarily? That's your reckless endangerment. That's what leads to the possibility of a manslaughter. Now, that's what leads to the charge. It doesn't mean that that's what a jury's going to find him guilty of. But the other thing that happens, which always happens in any of these cases, is we're anticipating facts we don't know. We don't have any idea what other information is out there. Presumably, a grand jury heard information which led them to believe that it was more than simply criminally negligent
homicide. Well, then why
homicide.
doesn't the grand jury in Staten Island get the same benefit of the doubt, that they heard all the evidence and they decided that it was not an indictable offense? Well, they did. Everyone's attacking them as being completely off the charts.
The implication was always that Donovan didn't put everything in front.
But that's a different story. Donovan, it's not. I think the grand jury gets used as a scapegoat. I never blame the grand jury. I look at what's put in front of that grand jury. What information? How is it set forth? What charges are they given to consider? We don't even necessarily know that they're given any charges to consider.
I got to get to this break here, guys, because we can keep going on this case here. But our next guest has got, I guess, terrific perspective on this one. I mean, you probably saw the story. A billionaire, many times over, got his way, and his estranged wife caves. Now, you'd say, oh, she got, railroad. She walked away with $1 billion, but many people still say she should have gotten a lot more here. We'll see what our guest has to say if the Oklahoma oil tycoon did well or not. Stay with us.
We are in the